right, welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. Appreciate all of you being here. It is Wednesday, April 8th, 2 p.m. here in conference room 325. My name is David Tarnas. I'm chair of the committee. We have our vice chair here, Representative Poi Poi, and our member, Representative Shimizu. Other members will join us presently. Here's one of them right here, Representative Garcia. For today, if you could limit your testimony to 2 minutes, that'd be great, so we can get through all the testifiers that want to testify and be able to make decisions on the bills today after we've received testimony on all the bills. There's a new microphone system in the room. If you haven't used it before, just come up to the podium as usual, speak clearly and loudly, just articulate. The microphone should pick up your voice. But heads up, the microphone is really sensitive, so it will pick up your side conversations just to your neighbor. So be sensitive to that so that you could try to keep that to a minimum. If you're testifying on Zoom, please keep yourself muted and your video off until you're testified. Turn it on for that, and then turn it off again after your testimony is complete. Use the Zoom chat function if you have technical issues, and our technical staff will do their best to help you. If you're disconnected, just please try to rejoin when you can, and if time permits, I'll have you complete your testimony when you rejoin. If the power goes off in the building here or something, fire alarm or who knows what, and we have to reschedule, I will make sure to post appropriate notes so everyone knows what we're talking about and when. If you're testifying on Zoom, please avoid using any trademarked or copyrighted images. That kicks us off of YouTube, which is a problem, because we want the public to watch us and watch you when you give testimony. And it's okay to disagree, but let's not be disagreeable. We're all here together to try to do what's best for the state. Okay, let's go ahead and take testimony on our measures today. First up, we have Senate Bill 2253, Senate Draft 2, House Draft 1, relating to highway safety. This measure amends the offense of negligent injury in the first degree to include injuries negligently inflicted by intoxicated drivers. First person said they wish to testify is from the prosecuting attorney, City and County of Honolulu.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Han Lam Chang Chang, and I'm testifying on behalf of the City and County of Honolulu Department of the Prosecuting Attorney. The department strongly supports SB 2253. Since 2024, I've been working closely with the Honolulu Police Department's Vehicular Homicide Unit to prosecute negligent and reckless drivers who cause critical and fatal injuries. SB 2253 does not elevate the penalties for all motor vehicle collisions involving impaired drivers. There are built-in gatekeepers to ensure that it only applies to crashes that lead to severe injuries. The idea behind SB 2253 is nothing novel. Under Hawaii's Penal Code, a driver who operates a vehicle in a negligent manner and kills another individual faces a Class C felony. However, if the driver is also intoxicated, the driver will be facing a Class B felony, which carries more severe penalties. The department pursued criminal charges against 20 drivers who operated a vehicle in a negligent manner and caused substantial bodily injury between 2021 and 2025. Of those 20 cases, 13 involved alcohol or drugs. However, all 20 drivers faced the same penalties, a misdemeanor, regardless if they made the conscious decision to drive while impaired. Every injury resulting from impaired driving begins not with a crash, but a conscious decision, and every decision is a foreseeable consequence of such a decision, and SB 2253 holds people accountable for these decisions, and we urge the committee to support SB 2253. Thank you for your consideration.
Thank you very much. Is there anyone else wishing to testify on this measure? If not, questions, members? I have a question, sir. I'd like to ask you, City and County Honolulu Prosecuting Attorney, this is a bill that was proposed by your agency, and I'm trying to understand it better. If you could help me. Subsections 3 and 4 expressly address cumulative punishment and the treatment of multiple injuries under subsection 1C. While these provisions clarify legislative intent as to that subsection, their inclusion could be read to imply by negative inference that cumulative convictions or separate offenses are not otherwise available under subsections 1A or B, even where such outcomes might otherwise be permitted under existing law. Was that intentional, or is additional clarification warranted?
I believe additional clarification could be warranted at a later time.
So that was not intentional.
It was not intentional.
Okay, so if the committee is willing, when we go into decision making, I may make a recommendation that we modify the language to make sure that and clarify it so that we're not making a negative inference saying that cumulative convictions, separate offenses would not be available.
That would make sense.
Okay, thank you. Any other questions? If not, thank you very much. Okay, Senate Bill 2429. Did you want to check the just split? Senate Bill 2429, Senate Draft 1, House Draft 1, relating to traffic safety. This measure establishes a framework for the use of intelligent speed assistance technology for habitual speeders. It establishes liability for a manufacturer, distributor, or retailer regarding the design, manufacture, installation, or repair of an aftermarket intelligent speed assistance system. It requires a report to the legislature and allows for probation for persons who are charged with excessive speeding. First up, we have the judiciary with comments.
Hello, my name is Jessica Orr. I'm the District Court Staff Attorney. You have our testimony. Just to briefly summarize, we are looking for a more clear definition of a habitual speeder. We're concerned about it applying to the traffic infractions, statutes. We also have some suggested language for the financial assistance and equity that might make more sense to follow 291E5. We have a small little correction for the rules section, and finally, we would love
Very substantive, but small.
we would love to have an effective date in July 1st, 2027 to allow us to prepare our judiciary information management system. I'm here for any questions.
Okay, great. Thank you very much. Next, we have Deputy Attorney General Mark Tom.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Mark Tom for the department. First off, I'd like to apologize to the committee for the late testimony submitted by our department. With that, the department does submit testimony with comments. Would point out just three different portions. I know that the judiciary just testified about the definition section of habitual speeder designation. I think it appears pretty clear that it's part 10 of 291C. So it appears that it would cover any of those speeding offenses which are infractions. And because it appears that it covers infractions, there is a concern that there's, as we mentioned in page 3, line 9 through page 4, line 11, there's kind of some areas of loopholes where when it's an infraction, two things. Limited court-ordered oversight. And additionally, there's ways to avoid coming in front of a court because infraction cases can be paid over the counter. And when it can be paid over the counter, either online through the courts, they're never coming in front of a court for a judge to adjudicate and determine that they are a habitual speeder and to then potentially order this device to be on their vehicle. So there is some issues if it does rise to the level of just infraction cases, which it appears it does. Last is similar to the judiciary. We did suggest amendments for the financial assistance and equity. We take no position on any of these issues. However, we pointed out two sections where the HRS already utilizes devices like the SCRAM device as well as the breathalyzer. There is sections that designate how that the vendor who has that contract might address these financial assistance. The way that the bill is written, it's the policy by the committee, but if it mirrors it, the vendors in those two sections would be responsible for the financial. The way that this is written, it says the court. So I'm not sure if that's intentional or if it's just an oversight. I just pointed out to the committee. We'll be here for any questions.
Okay, thank you very much. Next person, Tiffany Yajima, Alliance for Automobile Innovation on Zoom. Not present? Okay, anyone else wishing to testify on Senate Bill 2429? If not, questions, members? Just a quick question, Mr. Tom, looking at the judiciary's testimony and your testimony, is there a conflict between the recommendations between the two of you?
So as it relates to, I'd have to go more in depth of the judiciaries, but in brief conversation, it appears that it's similar for the financial portion. I think their recommendation is similar, that it should mirror where the vendor is responsible.
Understood, so that's similar.
So that's similar.
Okay.
In regards to the habitual speeder definition, it's a little different issue. I think it might actually be the same issue, but just written differently. Theirs is just getting clarification if it is encompass infractions. I think they pointed out 291C101, which is basic speed rule, and 102, regular speeding. However, the way that the bill is written, it does say part 10 of 291C. So I think that part 10 covers all those speeding infraction cases. So I think the overall issue that both departments are coming across is when it is an infraction, it leads to different problems than if you have excessive speeding, which is a petty misdemeanor, where there was an amendment made to allow probation. When there's probation, the individual would come in front of a court, and at that point, if it is adjudicated, they may order the device, and that could be part of the probationary term for, say, an excessive speeding if that amendment goes through with this bill. So it's just, I think it's the same issue, it's just approached in different ways if it is an infraction.
Okay, another question, the bill has a blank for the number of speeding violations within a 5-year period to be designated as a habitual speeder. There's also a blank where it says exceeding the posted speed limit by, blank miles per hour. Do you have any suggestions on what that should be?
The department unfortunately doesn't have a position in our testimony that can be addressed at this committee, but if the chair, we could
The deadline is we gotta move it if we're gonna move it.
understand.
But if the committee is agreeable to moving it forward to conference, we'll have to address those issues, but I don't wanna pick a number out of thin air. So I would like to get some input on that from you, and then if I could make the same request of the judiciary to assist us in this regard, unless you have any input today.
No, we really don't have any opinion on what speed.
Okay, so I would like to get a better sense of that, and it may be that you could speak with whoever your deputy AG that works with the Department of Transportation on this, so you can come up with something, but we'll need that to get through conference.
Will do, Chair.
Okay,
Thank you.
okay. Oh, one last thing, page 3, line 4. Would there be any issue where on page 3, line 4, when we're talking about the rules being adopted, I always like to use chapter 91, pursuant to chapter 91. Would there be any issue with that? I mean, you can't answer it, I guess, because it's not in your testimony.
I apologize. I will follow up and I will
So my intention is, I always like to use pursuant to chapter 91. It gives the public a chance to give input on it and other stakeholders. So you'll find that I do that sort of as a standard practice. But if the committee is willing and we move it to conference, I would look for your input on that, if that would cause trouble or concern.
I'll take that to
Take
the
that back.
department and I will follow up accordingly.
Okay,
Thank you, Chair.
okay, thank you very much. Any other questions, members?
Chair?
Yep, Reps Mizu?
If it's already been answered by your questions, please correct me, but testimony, your first paragraph you mentioned the habitual speeder designation, and then you end the paragraph with HRS 291C-161 may need to be revised accordingly. So you make that statement, but you don't comment on how it should be revised.
Yeah, because we don't really know what the definition is and if it is going to be covered traffic infractions, 291C-161 has the penalties. So if there's going to be changes to that to include traffic infractions, then that might need to be changed. We're not saying it has to be changed, it's offering that as a possible eventuality.
Those infractions are beyond the speeding with serious bodily injury focus scope. Is that
The speeding that we're talking about is sort of basic speeding, and then it gets higher and higher, and then you're going into excessive speeding, which are petty misdemeanors and things like that. So traffic infractions, like Mr. Tom said, they're just treated very differently in district court. So if we're gonna add something onto it, the definition just needs to be a little bit more clear, and 291's the penalties section, 291C-161 may need to be changed, but because we don't know the definition right now, we really have no ability to offer any kind of suggested language. Thank you.
DOT is not here yet.
No.
I wanted to ask DOT what they thought of judiciary's amendment on the payment, but I guess they're not going to ask that question.
Yeah, I understand.
Yeah.
So, and I have worked on some language to try to address that issue that judiciary brought up on habitual speeder, definitely, you know, how to trigger it. Okay, any other questions? If not, thank you very much to the testifiers. Let's move on to the next measure. Senate Bill 2697, Senate Draft 1, House Draft 1 related to transportation. This measure prohibits vehicles from driving on the shoulder of a roadway except in certain circumstances. Authorizes the Department of Transportation, law enforcement officers, and other approved persons to impound vehicles with expired registrations of 3 years or more under certain conditions. Requires an annual report to the legislature. Increases the fine amount for owners of out-of-state motor vehicles who fail to register the vehicle in the state, and establishes minimum and maximum statutory penalties for violations relating to the use of high occupancy vehicle lanes. On this measure, first up we have Michael Moriyama, Deputy Attorney General.
Good afternoon, Chair Tarnias, Vice Chair and members of the committee. Michael Moriyama, Deputy Attorney General. The Department of the Attorney General has two concerns about this bill. The first is regarding the penalties for driving on the shoulder of a roadway. Certain violations could be subject to both the $250 fine and the $1,000 fine. If a second violation was committed 18 months after the first violation, the second would be subject to the $250 fine because it did not occur within 1 year after the first infraction. However, the second violation would also be subject to the $1,000 fine because it occurred within 5 years of the first violation. The department recommends that the bill use a consistent 5-year period and use the language similar to HRS 291E-61, the DUI provisions for penalties for repeated offenses. The department is also concerned about allowing any approved or designated person or contractor to impound and tow unregistered vehicles. Impounding vehicles, even unregistered ones, is a drastic measure and may implicate constitutional issues involving due process and the taking of private property. Therefore, it is essential that the only DOT officials and law enforcement officers who are trained in the law and recognize constitutional risks verify registration status and then impound and order the vehicle towed. Thank you for the opportunity to testify. I'm available for questions.
Thank you very much. Next, no one else said they wanted to testify. Is there anyone else here wanting to testify on Senate Bill 2697? If not, questions, members? If
I have a whole bunch of questions for city and county.
not here.
Yeah.
Okay, if there's no other questions to anyone that's here, we'll move on to Senate Bill 2852. Senate Draft 1, House Draft 1 relating to civil rights. This measure requires the Hawaii Civil Rights Commission to adopt rules in digital accessibility. Requires the Hawaii Civil Rights Commission to adopt rules on digital accessibility for places of public accommodations that are consistent with certain federal regulations. Specifies that a violation of the rules is an unlawful discriminatory practice, establishes it as an unlawful discriminatory practice for a place of public accommodation to deny a person with a disability full and equal enjoyment of information related to their goods, services, facilities, privileges, advantages, or accommodations by requiring the use of information and communication technology that is not accessible to the person with a disability. First up, we have Hawaii State Council on Developmental Disabilities.
Okay, aloha Chair, Vice Chair, and committee members. I'm Megan Hahn, interning for the Hawaii State Council on Developmental Disabilities and for Daintree Bartolas, our Executive Administrator, to express our support for SB2852. We stand in support because as more services, payment methods, and just general information about public facilities become increasingly digitized, the council sees this bill's capacity to specify the statutes and violations for digital accessibility effective in ensuring people with disabilities are not being excluded to live full and dignified lives. Inaccessible websites and applications can become barriers to access basic goods and services for people with disabilities. So to reinforce our longstanding commitment to equal civil rights protection, we stand in support of this bill. Thank you for the opportunity to testify today.
Thank you very much. Next, Christine Pagano, Disability and Communication Access Board.
Well, Chair and committee members, I'm Brian McCare on behalf of DCAB and Christine Pagano. We are in support of this bill with defer to the Hawaii Civil Rights Commission and the AG's office for proposed amendments. Just would add, this is a really important bill, been important for several years now. It's depending on where court cases were filed, there were inconsistent rulings. And on top of that, now we have the DOJ revoking a lot of their guidance and changing their stances on accessibility related issues. So I think this is really important that we get something established at the state level for these protections. Thank you.
Thank you very much. Next, Sarah Ann Mao or Lauren Sugai, Attorney General.
Good afternoon, Chair Tarnas and members of the committee. Deputy Attorney General Sarah Ann Mao on behalf of the Department of the Attorney General. Our comments are contained in our written testimony. We just had one comment. We recommend removing the wording as amended to defend against potential unlawful delegation of legislative power challenges. I'm available for questions.
Thank you very much. Hawaii Civil Rights Commission on Zoom.
Good afternoon, Chair, Vice Chair, members of the committee. Constance Genscher for the Hawaii Civil Rights Commission. We stand in support of this bill, which clarifies that businesses that use digital communications to interact with the general public must also ensure that it is accessible to individuals with disabilities, as technology increasingly becomes a part of society in our daily lives. I'd also like to add that we support the amendment proposed by the State's Attorney General's office to better withstand possible legal challenges. Thank you for hearing this bill, and I'm available for any questions.
Thank you very much. James Gashel, National Federation of the Blind of Hawaii. Thank you for being here, sir.
Thank you, Chair Tarnas and Vice Chair Poipoi and members. James Gashel here, National Federation of the Blind of Hawaii. I just want to say I've actually kind of looked at my written testimony and reconsidered certain portions of it, so I'll just go through that real quick. You know, I think the HD1 version of this bill is just fine. It puts the emphasis more on regulations, which is fine. I just want to make the following suggestions in regard to that, because this provision just doesn't have dates that it should have in it, and some definitions. Here's my suggestion. I think you should consider adding back definitions that are in SB 1496 HD2. That's the essentially the same bill on this subject that this committee passed a year ago. And especially I would look at the definition of place of public accommodation, page 4, lines 4 through 7, because that mentions both physical and digital premises as being places of public accommodations. And I think that's important for the Civil Rights Commission to have authority to regulate on digital as well as physical places. Next, I'm gonna say that certain dates should be considered. By the way, there are other definitions in SB 1496 that you might look at and add back in, but particularly place of public accommodation. Then as far as dates goes, I would suggest, since word is that the Civil Rights Commission has a draft regulation, that that we say that the rules should be adopted by December 31, 2026. I'm not saying compliance date, but rules adopted, and then say compliance January 1, 2027. No, January 1, 2028, which gives a year for compliance. And if you wanted to stretch it out a little bit for, let's say, small entities, January, larger entities, January 1, 2028, and then everyone January 1, 2029. That way it would be phased in a little bit, which would be fine. Important thing is to enact a bill. Mahalo for your consideration.
Thank you very much, Mr. Gashel. I sure appreciate your testimony. Next person said they wish to testify is Mr. Peter Fritz on Zoom.
Thank you, Chair. My name is Peter Fritz. I'm an attorney with a disability and an advocate for persons with disabilities. My practice includes work under the ADA and related civil rights laws. I submitted testimony in prior hearings raising concern about earlier drafts. Those concerns were structural, not substantive. The civil rights purpose has always been sound, but the earlier draft placed technical compliance, such as certain definitions, and the earlier draft required conformance with the most recent version of the WCAG, which is 2.2. That meant that when the new version 3.0 was finalized, every business in Hawaii would immediately be bound by a new standard with no transition period, no hearings, no regulatory review, and the legislature will not have voted on the HD1 that fixes that. The structure adopted by HD1 that puts the disability, follows what has been done for more than 30 years in the disability law. It puts the discrimination in the statute, and then it follows up with rules. Those technical standards would be adopted by the Hawaii Civil Rights Commission. While urging restoration of certain original statutory language would place certain things back into the statute and would require amendment. The rules allow for public hearing, public discussion, and businesses to make things move forward. This is not a path to delay with the regulations. The Department of Justice completed its Title II web accessibility rulemaking in 8.5 months. They started August 23rd. They were finalized April 24. The Hawaii Civil Rights Commission already has a working draft of rules which includes those definitions as well as certain timetables, and the Commission doesn't start from a blank page. I urge the committee to pass this bill. I will stay around for any questions. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure, Senate Bill 2852, House Draft 1? If not, questions, members?
Question.
Rep. Shimizu?
Can I ask James Gashel? Can you educate me on how these provisions look like for a business to comply?
So,
Some examples maybe?
right. So for example, a kiosk where you would buy a ticket or make a payment should have a voice control so you could hear it as well as seeing a screen. And the technology exists to make this happen. It's just implementing it. Or an ATM machine, same thing. And you'll notice on most ATM machines there are outlets to plug in an earphone. Sometimes the voice is activated when you plug in the earphone, and sometimes it isn't. The machines are built so that they are accessible, but it's up to the bank to turn them on. And some banks do, some banks don't. This law would say they all should.
Can I ask one
Yes.
question to Hawaii Civil Rights Commission, please?
Go ahead. Yep, go ahead.
You know, in your written testimony, you had put the date April 24th, 2024, and then you stated that you were in agreement with the Attorney General who had June 24th, 2024, and it might be a small issue, but I just wanted to clarify that discrepancy.
Okay, yeah, so the April 24th, 2024 date was the published date that was published in the Federal Register. And the June 24th, 2024 date, I believe, was the effective date. So we're fine with going with the effective date and getting rid of the as amended language as well.
Okay, thank you. Thank you for that
Okay.
clarification. Thank you, Chair.
Any other questions?
Question, Chair.
Yes, Rep.
The
Garcia.
Attorney General? Yes, I'm looking through your testimony here and it says, as it currently is drafted, if your specific amendment is not made, that it would, that the bill as drafted may constitute an unlawful delegation of legislative power. Could you briefly verbalize that concern?
Yes. So the Civil Rights Commission does have rulemaking authority pursuant to Chapter 91, but by automatically adopting the amendments of the framework that has been established by the United States DOJ in the Title II Final Rule on Web Accessibility, it may be subject to an unlawful delegation of legislative power. And this is pursuant to the case State v. Tengen, which essentially pursuant to that case, state legislation which adopts by reference future legislation as the current version of the bill does, which adopts by reference future legislation, rules or regulations or amendments, like in this case, which are adopted by another sovereign entity, in this case, Hawaii Civil Rights Commission, it would constitute an unlawful delegation of legislative power, and that's just pursuant to the case, State v. Tengen.
Okay, thank you, appreciate it.
Thank you.
Thank you.
Thank you. Any other questions? If not, thank you very much to the testifiers. Let's move on to the next measure. Senate Bill 2471, Senate Draft 2, House Draft 1, relating to the powers of artificial persons. This measure reaffirms that artificial persons created under state law possess only those powers that are necessary or convenient to carry out lawful purposes, and that those powers do not include the power to spend money or contribute anything of value to influence elections or ballot measures. This measure revokes all prior grants of entity powers and regrants only those powers that the state determines to be necessary or convenient to conduct lawful business under the Hawaii State Constitution and laws of this state. First up, we have Department of Commerce and Consumer Affairs. Welcome.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Nadine Nando, the Director of the Department of Commerce and Consumer Affairs. And we had offered comments on this measure, largely because the regulatory and enforcement provisions of this measure are placed with the DCCA, the Director of the DCCA. And a big part of our concern with this is that in terms of what we currently do with regard to business entities. That is contained within our business registration division within the department. But that involves simply the really registration and collection of fees. It's a ministerial task. So we don't currently do anything that regulates what their activities are. And so this is a huge task to place within our department, and so we can't underestimate how much of a change that would involve to promulgate rules and to regulate this and to go after entities that aren't following what the measure restricts. So just to give you an idea, we currently register, as of January of this year, 207,000 entities. So I looked at this and I said, I posed the question in my mind, this is really aimed at restrictions in terms of campaign finance contributions. So thinking, we don't have anything to do with that. We don't do anything to regulate any of that activity. And I'm thinking, well, who does regulate that in the state currently? And it's under the campaign finance. I mean, it's campaign spending commission, which is under DEX. But then I don't see anything referencing here, any amendments to the campaign finance laws under the appropriate statutory section. So it's puzzling to me. And then I understood that when I was reading through the testimony of the Center for American Progress, this measure, it appears, is based on their research and a paper that they had published that proposes this as a different way of getting around the holding of Citizens United, the US Supreme Court case. And instead of following the normal tactic, which is to look at campaign finance laws, it's looking at doing something to corporate laws. And so to have the state restrict what entities like corporations and limited liability companies and partnerships can do. But the problem with that is you don't have anything in this measure that does anything to amend what's currently on the books under the campaign finance laws. And there are particular provisions in there in terms of campaign contribution limits. So, you know, this whole thing, it just doesn't seem like it all flows in really what should be at this point. If the state is going to do something this novel to get around the Citizens United decision, then I think it needs to be much more well thought. And in particular, how you're going to actually regulate and enforce this as your law. So that's something I wanted to, I'm going off script on that.
That's okay, I appreciate your voicing your concerns.
But I'm here for questions.
Thank you very much, Director. Next, we have State Health Planning and Development Agency. Not present. Next, we have Attorney General.
Good afternoon, Deputy Attorney General Christopher Hahn in strong opposition to the measure. We are well aware of how deeply unpopular Citizens United is. Heck, I don't think our department is a fan of the decision either. That said, we are asking this committee to take a long, hard look at the path ahead. Should this bill pass into law, we will likely face a legal challenge in the federal district court, where Citizens United is the law of the land. This bill may even work its way up to the US Supreme Court, the very body that issued Citizens United and created this whole mess. Nothing in the court's current composition today indicates that Citizens United will be overturned or rendered inapplicable on this measure. This bill relies on an untested legal theory, and we're concerned as to its viability. It's both overly broad in that it involves an unprecedented exercise of the state's power, and it's overly specific in that it only targets a specific type of speech. This bill revokes the power to engage in political speech for all artificial persons across the state. The sheer scale of this maneuver alone raises concerns as to potential unforeseen impacts. But what's even more alarming is that the revocation is limited to political speech only, which will likely trigger strict scrutiny as a form of content-based regulation. Regardless of whether the state characterizes a corporation's ability to engage in political speech as a power or a right, the freedom to engage in political discourse is a fundamental bedrock of our democracy that is closely guarded by the courts. For the purposes of the First Amendment, the speaker's status as a natural or artificial person is irrelevant. We understand that there is a strong desire to do something about Citizens United. This is a federal problem, and this bill's approach is just gambling with our taxpayers' funds. We know this is not an easy decision to make, but we do ask that the committee please defer this bill. Thank you.
Thank you very much. Next. Gino Sakena, Hawaii Building and Construction Trades Council. Not present. Next, Plumbers and Fitters, UA Local 675. Not present. Next, Marlene Tom, Indivisible Hawaii Statewide Network on Zoom. Please proceed.
Yes, aloha Chair Tanis, Vice Chair Poipoi, members of the committee. On behalf of Indivisible Hawaii, I am submitting testimony in strong support of SB 2471 SD2 HD1. This bill, as you've stated, reaffirms the powers granted to artificial persons. And those powers do not include spending money or anything of value to influence elections or ballot measures. It does not in any way restrict an individual's right to speak, organize, or participate in any democratic action. It simply defines the limits of what state-created entities can do as entities. For too long, we all know that corporations have spent unlimited amounts of money in political campaigns that led to super PACs flooding and tainting our elections with dark money. Now is the time to stop these practices by focusing on what powers the state grants corporations, LLCs, LLPs, or any other state-created entities. This bill will allow Hawaii to show the rest of the country what free and fair elections really look like. And your role in passing legislation that nullifies the harm that Citizens United has done will be long remembered and celebrated. We also agree with all the amendments that have been made to this bill, especially in House Draft 1. And we respectfully ask you to advance this measure as is and ensure that it passes the floor vote to be signed by Governor Green as the new and just law of the land. Thank you for the opportunity to testify.
Thank you very much. Dave Mullenix, Greenpeace Hawaii on Zoom, not present. Next, Nate Hicks, Hawaii Public Health Institute. Welcome, sir.
Chair, Vice Chair, members of the committee, Nate Hicks with the Hawaii Public Health Institute in support of the $10 million donated in the 2024 election campaign. Half of it came from just 800 donors. In addition, we had 3 non-candidate committees spending $13 million, far outpacing the rest of our democratic process. If we want to make sure our elections are by the people and for the people, we need to do everything we can to remove this undue influence on our elections. Please pass this bill. Mahalo.
Thank you very much. Next, we have Makana Hicks Gu on Zoom, not present. Next, we have Tom Moore on Zoom. Please proceed, Mr. Moore.
Chair Tanis, members of the committee, I'm Tom Moore, Senior Fellow for Democracy Policy at the Center for American Progress. I'm testifying on behalf of CAP in strong support of SB 2471. I want to thank the chair for scheduling this hearing. I know that members' time is valuable and time is short. The Attorney General's office has now testified repeatedly against this bill, and each time they have made the same fundamental error. They analyze SB 2471 as if it were a regulation of political speech. It is not. It is a definition of corporate powers. These are entirely different legal acts, operating in entirely different legal domains, governed by entirely different legal doctrine. As long as the Attorney General's office keeps making this fundamental error, its constitutional analysis simply does not speak to the bill in front of you. It is disappointing that even after months of testimony, supplemental analysis, and extensive case law provided to this legislature, the Attorney General's office has chosen to double down on its errors rather than reevaluate them. The Attorney General's office calls this mechanism untested and unprecedentedly dangerous. It is neither. The Supreme Court has affirmed the state's authority to revoke and redefine corporate powers for more than 2 centuries. This is not untested. It is just very dusty. The Hawaii Constitution specifically allows it. Article 1, Section 21 says the state's power to act in the general welfare shall never be impaired by irrevocable grants of special privileges. That clause was written for this moment. The Attorney General also says Hawaii cannot reach foreign corporations. This is wrong. Delaware cannot empower a corporation to operate in Hawaii. Only Hawaii can do that. Your own statutes say the foreign corporation may not exercise any power here that a domestic corporation cannot exercise. That is not new law. That is existing law. The Attorney General warns you'll get sued and you'll lose. I invite the committee to ask them today to cite a single case holding that a state must grant political spending power to its corporations. And if they cannot cite a case, and Citizens United is not that case, then this committee should weigh the rest of their constitutional analysis accordingly. I provided this committee with a written detailed response to the Attorney General's testimony. It was late and not in the packet. Apologize for that. But your legislative ancestors saw what could happen when corporations are set loose, and they left you a gift in your Constitution, the tool you need to reel them back in. I urge you to use this gift and move SB 2471 forward as is. And I look forward to your questions.
Thank you very much. Next, Cameron Hurt. Welcome, sir.
Good afternoon, Chair, Vice Chair, members of the committee. Good to be before you guys. We are here today to stand in strong support of this bill. I don't really know how to follow up what Mr. Moore said. I think he really nailed it. But the thing that I want to just drive in is that, again, what Citizens United addresses is using money as a way of free speech. This bill is not talking about that. This bill is talking about how are we defining corporations locally, which is a power that is granted to the states. What we're looking at is a issue really of states' rights of who gets to operate and into what capacity in their states. That's what this bill is addressing. It is not going down the Citizens United route of let's redefine corporations and their power to spend in elections. No, it's saying what is a corporation definitively in the state of Hawaii. And how that looks in Hawaii may look very different than how it looks in Delaware, and that's okay because our Constitution is set up that way for it to be okay. So I just wanted to add that, and we'll stand on our written testimony. Thank you guys.
Thank you, Mr. Hurt. Next, James Raymond on Zoom.
Aloha, Chair, Vice Chair, members of the committee. My name is James Raymond. I'm a retired Deputy Attorney General, but now speak only as a concerned citizen in strong support of SB 2471. I'm not here to persuade you with the legal merits of this bill's novel solution to the corruption of our election system unleashed by Citizens United. Tom Moore of the Center for American Progress, CAP, and others have already done an admirable job of that. This bill is set on firm legal grounds. There may be colorable arguments on either side. You won't get an argument from me on that point. But arguments to the contrary that it's unconstitutional are actually distractions or pretext, and they are advanced by those whose real agenda is to preserve big dark money in our elections. Please don't lose sight of the fact that when the legislature wants to fight for an issue that may be challenged in our courts, it's the AG's role to defend the legislator's position, not to be a foil for the governor's special interests. Despite our AG's dim view of the bill, 3 legislative committees have already heard it and passed it, all with unanimous aye votes, and only 2 excused, not to mention a 25-0 aye vote in our Senate. What could account for such strong support from the legislature in spite of naysaying from the governor's AG? Well, this brings us squarely to the elephant in the room, and I don't mean the Republicans. You and your colleagues are being asked to approve a bill that has real potential to stop the lion's share of campaign funding relied on by some key Hawaii legislators, not to mention the governor and lieutenant governor. It sounds very much like a conflict of interest. Yet, it's extremely well documented that we the people want Citizens United and the big dark money that comes with it rendered moot. My fear is that when push comes to shove, as the bill moves through the process, that all those enthusiastic eyes, all those enthusiastic eyes may fade. Will legislators who rely on PAC money protect their campaign funding? Or perhaps their relationship with the governor? Or will they work with their colleagues to override a governor's likely veto and represent we the people? Please keep in mind that just voting aye for this bill is not enough for it to succeed. You must rally your colleagues to actively support it in the House and to override governor's veto if needed. This is a position that will show your constituents that you represent them and not corporate special interest. They will be watching like never before. I ask you to join your sister states and we the people in the fight to save democracy and pass this bill, not because it is risk-free and our AG is solidly behind it. It is not risk-free and she is not solidly behind it. I ask you to pass this bill and start writing the legacy your descendants will learn about your role in the fight to save our democracy. I remain available for questions. Thank you.
Thank you very much. Matt Lopresti? Not present. Next, Christine Andrews on Zoom? Not present. Next, Josh Frost? There you are. Welcome. Please proceed.
Thank you, Chair and Vice Chair, committee members. I really appreciate you guys putting this on the agenda. I know you've got a lot on your plate. Of all the bills that first let me say I'm here as an individual. I'm not representing the ACLU or any other organization. The ACLU or the Citizens United ruling has been something that I've spent time on in my own capacity since 2010. I've helped draft resolutions against it and done my own reading. You have my testimony. You've heard from people that frankly are better suited to talk on this, the details than I am. So I wanted to sort of talk about some of the questions that may come up or that have come up in other conversations. The bill will absolutely impact nonprofits of every color and variety. It will impact labor unions and their ability to spend all on the same footing. Just like the Citizens United's ruling impacted all those organizations, so will this bill. That said, unions will still be able to spend money to communicate with their members, just as they do now, right? They can send political flyers to their own members. That wouldn't be prohibited. It would be election spending that's prohibited. Unions and nonprofits would arguably be better positioned if the bill were to become law, because they have a built-in constituency in which to raise money, which they could then spend on elections. What the bill does is says you can't spend out of your treasury on elections. That doesn't mean you can't go out. You could still, a corporation could still create a PAC, right? But they couldn't contribute directly to the PAC or to the C4, right? That organization would then have to go out and solicit money from whoever to raise money to spend in elections. Unions are already an advantage in this. They have a built-in membership and constituency. Nonprofits like the Sierra Club, Common Cause and others have built-in constituencies that would allow them to raise funds to then spend on elections. There are lots of things that I think we, all think are troubling about our democracy at the moment. In my opinion, Citizens United, if it hasn't already been murdered, democracy is seriously in jeopardy. And I think Citizens United can be traced as one of, if not the main reason why we're in the situation we're in now. So despite concerns from the AG, and I know, you know, some of the labor unions, whatever, I implore you to please move the bill forward.
Thanks very much. Christina Holt on Zoom. Please proceed.
Thank you, Chair, Vice Chair, and members of the committee. My name is Tina Holt. I'm coming to you from Hilo today as an individual in strong support of SB 2471. This is a slam dunk. It's not even a partisan issue. Polling consistently shows over 70% of Americans across party lines want limits on corporate political spending, because people across the political spectrum have lived through disaster after disaster. After Citizens United, we all know what happened. And something that makes this particular bill kind of infuriating in the best possible way is how simple it is. And often the most simple solutions are the best solutions to our issues. It rests on over 200 years of corporate law, the foundation that has always said that the state gets to decide what powers corporations get to operate within that state. We, the state, give them everything that they need to do business, and the state never ever intended to give them the power to buy our elections. So this bill just like clarifies and helps us remember the power that we have, honestly. An earlier testifier commented that this should be a campaign finance bill, not a corporate law bill, but I think that misunderstands where the problem started. The courts found political spending hiding inside broad grants of corporate power, and this bill removes it from there. That's not regulating elections, it's further defining the entities that the state created, being corporations, LLCs, nonprofits, etc. Another testifier warned that this will be challenged in the court on First Amendment grounds, and I say good, let them try. The First Amendment protects natural persons, and it does not protect unnatural persons. This bill does not touch natural persons at all even. It just defines in our state what an artificial person is. Again, which is just a legal thing, a legal idea that is created by the state. The state created it, the state defines it, and that has never been seriously disputed in over 200 years of corporate law. So even if it made it all the way to the Supreme Court, for the Supreme Court to strike this down would force them to unravel the entire foundation of corporate law in every state across the country. That would be insane, like even at the level of insanity that we're seeing on our Supreme Court right now. So again, let's just be clear, this doesn't silence corporations, they can still form PACs, it just brings the money into the light so that we can see where it's coming from, where it's going, and who is funding these things. They can participate in the political process through entities that are purpose-built for that. So I'll just wrap up by saying, like, I'm 35 years old. I did all the things right that I was told to do growing up. I went to school, I work hard, and like most people in my age range, the promise that we were sold, one job, one house, one family, is way out of reach. Not because we failed, not because we like avocado toast. It's because the system was being tilted against us while we were just trying to get our education and survive. Citizens United passed in January of 2010. I was just 19. We were in the throes of the Great Recession. Working families were losing their homes, their jobs, their savings, their futures. The wealth gap was exploding when ultra wealthy were vacuuming up every single thing they could get their hands on. And that is the world that Citizens United came into being under. We have such an incredible opportunity to change the landscape going forward. So please pass SB 2471. Let Hawaii be the one that shows the entire country what we can do when we stand together and tell corporations enough already. Thank you.
Thank you very much. Teresa Armbruster.
Aloha, Chair and committee members. I'm Teresa Armbruster, and I oppose this measure because it does not reaffirm anything. In the past, corporations in this state were always given the same rights as individuals. And in this session alone, they're trying to redefine what a corporation or nonprofit or any organization is. They're trying to redefine it as artificial. And I still agree with the interpretation that corporations and all these entities are groups of individuals, and therefore they do maintain the same constitutional rights. And as the other judge read, there's 207,000 entities here, and I will contend that not all of these are big, bad corporations that want to have undue influence in our elections. There are many that are small, and when they formed, they do want to have a collective voice. There may be some measures, ballot measures, that may directly affect their organization or their association, so they should have the right to have a say on that ballot measure. And this is gonna take away that power from all of these. And also, I still have a question. If there's gonna be 207,000 different entities here that are gonna be affected by this, when are you gonna spring this on them? After the bill comes in and say, oh, by the way, all your powers are revoked. You only have powers that the state says you have now, and specifically, you cannot get engaged in any election or ballot measure activity. And if you do, we're gonna disband you and take away all your privileges. I don't think that's good business ethics, for one thing. Is that showing aloha to all these entities that are in our state? Many of them, you wanna take their money for their dues and all the good that they do for the state, but no, you can't have a say in elections. I really don't think that's right. I'm only an individual, but this is my 2 cents worth. And also, I do know that there are gonna be legal challenges, and if we get sued, you're gonna waste all of our tax dollars paying all of these gigantic legal fees. And so I don't think that's good stewardship of our tax dollars, and I really do not think it's wise to ignore all the legal advice of our Attorney General. So for these reasons, I ask you to vote no on this and seek some other form of campaign spending reform. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure? If not, questions, members?
Question, Chair.
Rep. Shimizu.
Attorney General. You know, I don't know if you saw the testimony from Hawaii Building and Construction, and they feel like as a organization, they will be limited in their campaign supporting efforts. And I guess I needed or wanted clarification on the scope of what this bill would prohibit as far as an organization like that doing their traditional campaign support for any candidate that they endorse.
Well, this bill is pretty comprehensive. I'm afraid I'm not exactly familiar with how the entity you've referenced is organized, but assuming they're a nonprofit, whether they're incorporated under Chapter 414D or unincorporated under 429, both are in this bill. And
so like if they go sign waving, is that prohibited?
you know, I'd have to reread the bill, but you know, it's part of it is if it's doing it in its capacity as an entity, it could pose some issues.
I have another question, but I'll defer for
Okay, Garcia.
AG as well. So how do you respond to the common arguments we've heard today that this is about states' rights and that this isn't really pertaining to Citizens United, but in that it's actually just defining what a corporation is here in Hawaii?
Thank you for the question. So I think the common pitfall and mistake that everyone's falling into right now is it's so beholden to the state's corporate making powers that it ignores the fact that any exercise of the state's power still has to comport with the limits of the Constitution. So, for example, if the legislature were to pass a law saying that all businesses have to discriminate against Native Hawaiians, take away the power to serve Native Hawaiians, do you think, would that pass constitutional muster? I think we all know the answer to that question. Now, speaking from personal experience, because right now I am defending 3 constitutional challenges in federal court for a bill you guys passed last year, Act 143, formerly HB 712, relating to the 340B program. And what happens in these proceedings is the court doesn't get into where the state's powers comes from because the principles of federalism are pretty cut and dry. what the main inquiry and the issue that gets litigated is, what does this bill purport to do? What does it do? Does it pass the smell test? Does it walk like a duck? Does it quack like a duck? Then it's gotta be a duck. And so the first question that's gonna pop up if this proceeds to litigation is, what does this bill do? What effect does this have on speech? And under the First Amendment framework, because with the First Amendment, the core principle of freedom of speech is that it's supposed to be a free exchange of ideas, a marketplace, so to speak, where goods and ideas can come in. It's not so much focused as to where the ideas come from, it's just about whether the ideas can get in or not. And so even if you make this distinction between who the this whole distinction that corporations are not people, that doesn't matter. Even if we make the distinction that it's the state that's granting the power as opposed to a pre-existing right and we're taking it away, the idea itself, the expression is being prevented, and that's what's that we're afraid is going to run afoul of the First Amendment.
Thank you. Rep. Belatti?
I have a series of two sets of questions for, sorry, your name, sir?
Chris.
Mr. Mr. Chris. And then I have questions for Mr. Moore following this. First set of questions, let's see. I'm interested in the process with which the AG came to the opinion that it came. Was this something that was mooted or vetted amongst a team of attorney generals, or was this a memo that was analyzed under the aspect of under the purview of one attorney and then moved up the chain of command? How did the opinion get formulated?
We've had several of our best people take a look at it. We've had several opinions on it.
Okay, do those opinions include someone with a more corporate law background that could bring the framing of the state's rights and the corporate insights into the analysis that your office conducted?
Not quite sure if I'm familiar with the backgrounds of all the deputies who are involved, so I would have to follow up with them.
Okay, I think that's important because yes, we acknowledge that this is a novel approach, but really there should have been a team of attorneys probably looking at this to be able to look at it from the different, as you said, perspectives, whether it's the constitutional First Amendment or if it's coming from the other framing that Mr. Moore and legal experts across the country are formulating this opinion on. So that's something I think it would be interesting for you to give us feedback as to what's the background of the attorneys who came up with the opinion. My second set of questions, and I thank you for sharing with that because I think that's really important. Did your team look at what past state legislatures have done with respect to Citizens United?
I'm afraid I don't know the answer to that.
Okay, so if I were to tell you, would you be surprised that 2 years after Citizens United passed, there was a Senate Resolution 68 that actually passed out of the Senate to urge Congress to propose amendments to address Citizens United? Would you be surprised if I were to
No, I think I read that somewhere actually.
Okay, and I think it's really great. So I actually disagree with one of the testifiers here who says that, you know, we have lawmakers here, former lawmakers here who are beholden and wouldn't want to see this change, because actually I would urge you guys to look at Senate Resolution 68 from 2012. Then lawmaker Josh Green was the primary introducer of that. Would it surprise you to know that in 2013, HCR 10 was adopted by the House, and the leader on that bill, and there was dozens of lawmakers who adopted that amendment and introduced that amendment. That would have been Representative Takayama. Would you be surprised by that?
No, I'm not.
Okay, how about, there's actually a number of bills, 2015 and 2017, or not bills, resolutions, calling because the legislature felt frustrated and saw what was happening with Citizens United, and that our only mechanism at that time was these resolutions. Would you be surprised that in 2016, actually both House and Senate adopted House Concurrent Resolution 29, again urging Congress to do something to address Citizens United? Would you be surprised by that?
Not surprised.
Would you be surprised that it also included introducers who are Republican and Democratic?
Not surprised.
Okay, now I want to go over this because this is really important, because this is expressing the ways in which the legislature has been looking for a policy solution. The last time action was taken before 2026 was 2019. Would you be surprised that it was a Senate concurrent resolution introduced by Carl Rhodes?
I'm not surprised.
Yeah, not sorry, but you know what his proposal in that was? It was to convene a national constitutional convention to open up the United States Constitution so we could address Citizens United. Do you know what Senator Rhodes did with that?
I do.
He actually deferred that bill because he recognized that that was not an avenue. Now, fast forward 10 more years, we have this piece of solidly researched legislation that is moving in multiple states and in red states like Montana. Is it not conceivable at all to the Attorney General's office that this is a potential, a real potential, if the legislature passes it, that the arguments on the side that it's being advanced by the Center for American Progress are more than defensible?
No, we don't think so. If we thought it was defensible, we would speak out against this bill.
Okay, thank you. I think that's disappointing because I think, we ask corporations and we empower corporations to do things a lot of times. And let me just say, like, for example, the Prepaid Healthcare Act is something that we've asked them to do and they comply. If we define their powers as has been reserved to us in our own state constitutions, I would hope that the Attorney General's office, if that is how the legislature speaks and it survives, then one of the first defenses that the Attorney General's office has to take is that anything that is passed by the state legislature is presumably constitutional. So isn't that true? That you would have to defend it because you presume it's constitutional because we have enacted it as a legislature. Is that not part of the arguments?
Now, I understand our department's role to enforce and uphold our laws as opposed to the presumption of constitutionality. I won't get into the weeds, but I mean, right now I'm just thinking of presumption against preemption, and there are certain conditions for that, so I won't get into it. But I would certainly hope that the courts look more favorably upon a state's legislatively enacted laws.
Thank you. I have a series of questions for Mr. Moore, and I'm sorry, thank you for indulging, Chair.
Any other questions on this side?
I have a
If not,
question.
Rep. Shimizu? Then I'll come back.
Attorney General, thank you for being here and patiently answering questions. You stated in your testimony regarding foreign corporations, and my understanding that as far as foreign corporations, there are existing limits and requirements that are already in place. Are you aware of that?
I'm afraid I'm not too familiar with those existing
Yeah,
requirements.
I wish we had somebody from Campaign Spending Commission here, but as a candidate, we have to abide by campaign finance requirements, and there are limits that a foreign corporation can donate to any candidate. So if those limits are established in our current laws, would those similar requirements be able to be translated to a non-foreign corporation?
That's a good question. I'm hesitant to, I'm not trying to dodge the question, but
Sure.
I don't have a definitive answer for you right now at this point, so I do apologize for that.
Okay.
Would you be able to get an answer at a future moment in time?
Sure, we'd be happy to look into it, although I think we would just wanna know what specific provisions you've had in mind that you're referring to right now. That would probably help us.
I mean, it's current law as far as foreign corporation donation, so probably could look that up sooner than I could. Yes. So could you respond to my?
Sure, will do.
Thank you.
Okay, do you have another question?
For Mr. Moore.
Okay.
Mr. Moore, are you still there?
In your
I am,
responses, Mr.
thank you.
Moore, if you could, in your responses, Mr. Moore, if you could try to be as succinct as possible, that'd be great, because we have a lot of bills on the agenda. And I know this is an area of your keen interest and expertise, so if you could just keep it succinct, that'd be great. Please proceed.
It's a fair warning.
Thank you. Mr. Moore, first set of questions is about the concerns raised in the DCCA testimony about the enforcement. As I understand this, how is this going to be enforced, to make sure that corporations are complying with not using their treasuries to contribute to elections?
Just as this is a very different way of approaching this, in not doing regulatory moves, but instead of it's a power granting move. The enforcement is very, very different also. It is this ultra vires doctrine, which has not been used much in the last 100 years, but is as strong as it ever was, and it was fearsome in the 19th century. And basically it says, look, if there's some action that a corporation takes that's beyond its powers, and in this case it would be exercising political spending powers, if you don't have that power to do that anymore, the state can basically give you the corporate death penalty. There are all kinds of other things that can happen too, but the Attorney General can go in and sue you and say that you have to lose your charter. But the way that it mostly gets enforced is by private parties who go to court and say, hey, this corporation did an ultra vires act, these consequences have happened, hey court, make a determination about that and then we'll proceed on this case. And so those are case-by-case determinations that are made in court. And the only way that the state government, kind of that apparatus, needs to deal with that is when a court order comes out and says, like, yes, these guys have lost all their privileges, or these guys have had their charter yanked by the Attorney General, or this corporation has had its privileges reinstated because they did what the court said. It is not a major undertaking by the executive branch of the government to keep track of all this. They do not have to track campaign contributions or anything like that.
Okay, second question is concerning foreign corporations. You heard this testimony about concerns about foreign corporations. Can you expand on that and how that this isn't presenting a problem that the Attorney General's testimony is presenting?
Well, there's a couple different ways of thinking about this. One of the things the Attorney General mentioned in their testimony was that the state of Hawaii doesn't have any authority to tell a foreign corporation, an out-of-state corporation, what it can do in the state of Hawaii. And that is absolutely wrong. This is a power-setting exercise, and basically whatever powers the state of Hawaii sets for its domestic corporations, foreign corporations have to go with that as well. And the statute for that is 414D275. It basically says that they've got exactly the same rights, privileges, powers that a domestic corporation has. So, and most states have this. This is a very, very common provision. So there's nothing unusual about it, and it gets invoked all the time.
One last question, and this has to do with the unions, because I think there's a concern. We have a number of testifiers representing the unions. Somehow saying that their ability to participate in election speech is going to be curtailed. My understanding is that labor unions at the end of the day are still going to be able to have their own PACs. They will be able to solicit money from their members. They will still be able to participate. Can you explain that further?
Sure. One way to think of it is just rolling the clock back to the day before Citizens United was decided. That day, unions could endorse candidates. They could send membership. They could send messages to their membership about things. They could do voter registration drives. They could do nonpartisan voter, get out to the vote efforts. All kinds of things like that. They just couldn't write a check out of their treasury to a PAC, or to a candidate. Citizens United, after Citizens United, they could write that check for political things. Before Citizens United, that kind of political activity was done by their PAC. And those are voluntary contributions. They have to ask their members to give instead of the mandatory contributions that are sitting in their main checking account. And basically, this just goes directly back to that. And I agree with the other testimony earlier that any kind of membership organization has a pretty good advantage here, because they can solicit every single member of the union or every single member of the Sierra Club to give to the PAC. where business corporations and others, the class of folks that they can solicit are much more limited. So it is definitely a big change in the way a lot of labor organizations do business, the way they've adapted to Citizens United, but they should be able to adapt very well.
Okay, just one last question. So I just really want to emphasize this because I think what is really important for the public and for lawmakers to understand is that what this bill is actually doing is shutting down the corporate treasury, which in any situation will always outweigh actually the union's base, right? I mean, that's what this bill is ultimately doing. It's shutting down those huge unlimited corporate funds that the unions cannot ever actually compete with. Is that a correct way of understanding this?
Yeah, that's right. I mean, it's basically the numbers are iffy because it's hard to tell how much dark money exactly is being spent. But most of the research shows that labor unions have been vastly outspent in the Citizens United era, where they were not before. You know, they were outspent by a bit before Citizens United, but you know, it's the amount of money that corporations and dark money C4s have been able to marshal to spend in politics just dwarfs what labor's been able to do. So it's you know, labor has adapted well, and there are certain kind of organizational advantages to just being able to write a check for it instead of having to beg your membership for it. But take 2 steps back, and they're getting killed. So it is not clear to me that their opposition is their best path forward.
Thank you. Thank you, Chair, for indulging.
Sure. Grateful to have the discussion. Okay, let's move on. If that's okay. No more questions. We'll move on to the next measure. Thank you to all the testifiers on this very important measure. Let's move on to Senate Bill 2568, House Draft 1, relating to offenses against public servants. This measure elevates the offense of harassment to a misdemeanor when committed against a public servant because of or during their performance of official duties. First up, we have the judiciary.
Good afternoon, Chair, members of the committee. My name is Terrence Lee. I'm a staff attorney for the Judiciary's Administration. The Judiciary is in strong support of this measure, which is part of our legislative package. And we just wanted to quickly emphasize to the committee that the intent of this bill is to provide a wider array of sentencing options to the court in situations where a person has been convicted of harassment of a public servant. And if the court happens to find that the circumstances are such that stronger, higher penalties are warranted, that the court has that available to them. Certainly also if the court finds that circumstances dictate that lower penalties are warranted or no jail time, for instance, it certainly can do that under this bill as it can under present law. We are very thankful to the committee for putting this measure up for hearing today, and I'm available for any questions. Thank you.
Thank you very much. Next, the Department of Education. Not present. Next, Hawaii State Commission on the Status of Women. Yasmin Cheney, welcome.
Good afternoon, Yasmin Cheney for the Commission on the Status of Women. We stand on our written testimony in support of this measure as public servants play a vital role in upholding essential services and ensuring the effective functioning of our government. And their ability to perform these roles without fear of harassment is critical to public trust and safety. We thank the committee for its consideration and support.
Thank you very much. Office of the Public Defender. Not present. Anyone else wishing to testify on Senate Bill 2568? If not, questions, members? If not, yes.
I'm just curious.
Thanks for taking that tact. I appreciate it.
What is the tipping point or the line cross where First Amendment rights crosses the line into harassment?
Yeah, so I'm not a constitutional law expert, but I would point out that what this bill does is it takes the existing harassment offense and it simply raises the grade of the offense so that higher penalties can be imposed. And so from our perspective, this bill doesn't pose any constitutional issues any more than the current harassment offense that appears in our penal code today.
Understand. Okay, thank you.
Okay.
It's there. Thank you.
Yep, thank you. Any other questions? If not, thank you very much to the testifiers. Let's move on To the next measure, Senate Bill 2151, Senate Draft 2, House Draft 1, relating to emergency management. This measure clarifies state and local authority during a state or local state of emergency, defines catastrophic harm and severe weather warning, amends the definition of disaster and emergency under Chapter 127A, allows the legislature to terminate a state of emergency and county councils to terminate a local state of emergency. First up, Ted Kafalis, Grassroots Institute. Not present. Next, Drew Hara, welcome, with Earth Justice.
That's right, thank you, Chair. Chair, members, Drew Hara, Earth Justice. So we submitted testimony in support of this measure. We'll stand on that. Just wanted to emphasize a couple things, make a few additional comments in response to testimony and opposition from our emergency management agency.
You're testifying in support.
We are testifying in support, yes. Thank you for that clarification. So what this bill, there's concerns that this bill would somehow hamstring or limit HIUMA's authority. And I just want to clarify that that's not the intent of this measure, and that would not be the effect of it. The amended definitions of emergency, disaster, and catastrophic harm are really intended to bring this measure back in line with the legislature's original intent for our emergency management statute 127A, as stated in the policy and purpose section of 127A-1. And also, in terms of preparedness, training, response, education, those are all powers that would also be untouched under 127A-12, which are available to the governor and the mayors to coordinate with our state and county agencies and our federal agencies outside of emergency periods in order to prepare for evolving situations or be forward-looking in our disaster response approach. So all of that would still be well and good under this provision. Really, specifically, this is intended to bring back constitutional balance of powers in direct response to the Supreme Court's Nicole decision issued at the end of last year. Available for questions, and again, in support of this measure. Thank you.
Thank you very much. Margaret Najia, the Hawaii Christian Coalition. Not present. On Zoom? No. Not present. Anyone, Teresa Armbruster? Teresa Armbruster? Teresa Armbruster, you're next.
She's out there, check Margaret, anyway.
Well, hopefully Margaret will come in, so I'll ask her to come up after you. Go ahead first, though.
Okay. Good afternoon, Chair Tarnas and committee members. I'm Teresa Armbruster, and I oppose this in the form that it is right now, even though I appreciate some of the changes that were made in previous amendments, but some of the major concerns is that still needs major amendments in 127A-13 and 127A-14. And in particular, if it was up to me, I would repeal the whole section of 127A-13, but it still needs major amendments in some areas, especially addressing the quarantining and separation groups based on the governor's opinion that someone may have been exposed or groups have been exposed, and I think there needs to be more looking into that, just not based on opinion about, and then also about being able to seize or destroy property, and also about seizing firearms, being able, a warrantless attempt to go onto private property without permission or even notice. And also, let's see, there's other things, that was just some of them. But what we could do is if you're not gonna change that or rewrite this whole section, some of the major amendment that could not go against our constitutional rights, because each one of these would be an infringement on the rights if it's not kept in check. So I would make sure you explicitly put in that section that emergency laws shall not suspend constitutional rights, shall not infringe on due process, and shall be narrowly defined for that declared emergency. And also in 127A-14, and also in 127A-13, gotta remove all the phrases say in the governor's opinion, because that is too subjective. There needs to be some more facts or evidence to justify some of these actions that are in 127A-13. So I really would recommend that. And also in 127A-14, removing the sole judge for governor and mayor. Because in other states, a lot of times, even before they can declare an emergency, it has to be approved by the legislature. So I would even suggest exploring that before they can even declare the emergency, you should have a consensus on. I know some things you may have to declare it right away, depends on the situation. But I would explore that option, also about even the extensions that would be legislative approval. Because that's how you keep some more of this in check, as opposed to these ongoing proclamations and extensions, and not just the termination, but these extensions can, you know, keep going on and on. So I would really look more at that, because that's how it's gonna be more balance of power, more legislative oversight. But also, I really do wanna make sure in that 127.813 that you explicitly put that it's not gonna violate our constitutional rights. And so I just thank you very much for this, and I just hope that we can really make these amendments before, not just keep it as is. So thank you very much.
Thank you, Ms. Armbruster. Back to Margaret Mejia. I'm glad we found you.
Thank you.
Please proceed.
Okay. Aloha Chair, Vice Chair, and members of the committee. My name is Margaret Mejia, and I'm submitting testimony on behalf of Hawaii Christian Coalition. We oppose SB 2151 relating to emergency management. I've been told by legislators and attorneys that this bill was written to curb the powers of the governor. However, the exact opposite is true. Chapter 127A grants the governor sweeping powers, and without repealing that statute, SB 2151 cannot curb the governor's powers. First, it should be acknowledged that since March 2020, former Governor Ige had over 40 emergency proclamations, and Governor Green had over 90. So that's over 130 emergency proclamations, and that's way too many emergencies. Second, it should be noted that SB 2151 contains the following wording. It says, in the governor's opinion, 4 times. Page 5, line 13, page 5, line 16, page 6, line 2, and page 10, lines 20 and 21. The governor deems necessary is on page 7, line 13. In the opinion of the governor, page 8, line 19. The mayor deems necessary, page 12, line 17 and 18. The governor or mayor shall be the sole judge, page 14, line 19. And believed to have been exposed, page 5, lines 11 and 12. Because of the words that were chosen here, it looks like the legislator is putting the governor's opinion and the mayor's opinion above the law. The governor cannot predict the future. However, this bill contains words like imminent threat, page 4, line 3, page 4, line 17 and 18, page 14, line 16. Imminent danger, page 14, line 16. Likely to cause, page 4, line 20. This wording should be removed. Also, suspending laws should not be tolerated. Suspending laws is on page 6, line 21, page 7, line 12, line 13, and line 13, line 15, line 16, line 18, and line 20. All of section 4 on page 8 is in the opinion of the governor. Page 12, lines 3 and 4, page 12, line 11, and page 13, line 3. For the people of Maui and for all the people of the state of Hawaii, the governor should not be allowed to turn off water mains in case of a fire. Page 9, line 9, page 13, line 11. After thorough review of the existing statute, Chapter 127A, Hawaii Revised Statute, SB 2151, and the Hawaii Constitution, we strongly urge the legislature to repeal and replace Chapter 127A in its entirety. Chapter 127A is critically flawed and fundamentally dangerous in its current form. Its overall structure concentrates extraordinary, unilateral authority in the executive branch in ways that are gravely imbalanced, inconsistent with meaningful legislative oversight, and incompatible with the separation of powers. The statute grants the governor sweeping powers during a declared emergency, including suspending current laws, requiring quarantines even for people who are believed to be exposed to any infectious disease, in the governor's opinion, and authorizing entry on private property without a warranty, seizing firearms, authorizing taking over infrastructure facilities even if they're privately owned, regulating or prohibiting business transactions, enabling the governor to force vaccinations. These provisions violate fundamental rights protected under the Hawaii Constitution, including due process and equal protection, Article 1, Section 5, including the right to privacy, Article 1, Section 6, and protection against unreasonable searches, seizures, and invasions of privacy, Article 1, Section 7. Similarly, they violate rights under the United States Constitution, including protection against unreasonable searches and seizures, the Fourth Amendment, due process protections for life, liberty, and property, Fifth and 14th Amendments, the right to keep and bear arms, Second Amendment, freedoms of speech and the press, First Amendment, particularly in the case of media or communication restrictions, and through broad implementation of emergency rules, law suspensions, or movement evacuation controls, potential restrictions on the freedom of assembly and association.
Ma'am?
Yes. So SB 2151 acknowledges structural deficiencies in Chapter 127A. Do appreciate the amendment from supermajority to simple majority. And we're willing to work with you on future amendments to this bill. But we can only support this bill if further significant amendments are made. And I just wanted to end with Article 3, Section 1 of the Hawaii Constitution. It says, "The legislative power of the state shall be vested in a legislature, which shall consist of 2 houses, a Senate and a House of Representatives. Such power shall extend to all rightful subjects of legislation, not inconsistent with the Constitution, with this Constitution, or the Constitution of the United States." So effective management is a rightful subject of legislation, but suspension of law should not be tolerated. And there's just some other amendments. I'm open for questions and also open to work with you folks on amendments. Thank you very much.
I appreciate your testimony and we did receive your written testimony, so I appreciate that very much.
Okay.
Anyone else wishing to testify in this measure? Yes, please come on up one at a time and introduce yourself, please.
Aloha, my name is Alice Abelanita. I'm a citizen of the state and this bill is one of the most disturbing bills I think I've ever read. And it talks about the lack of due process, that they're giving the governor sole sweeping power to make a judgment on what he deems to be an emergency. And no one should have that kind of power. That's why we have the legislative branch, like she said. I agree with everything that she brought up, and it's in the bill. If you read it, there is disturbing. He's being able to seize property, quarantine without due process, and he can take your firearms and at his whole sole discretion. This is not okay. It's not okay. And you know what? You folks swore an oath to the Constitution. And this bill is violating the Constitution in so many ways, it's very disturbing. And so I don't even know how it's gotten this far. He has declared over 90 emergency proclamations, and even the one from Lahaina is still going. He just keeps, they're supposed to expire after 60 days. So why does he have, and a lot of his proclamations are not even an emergency. An emergency would be like Lahaina or the storm, but you know what, he's suspending laws and he's procuring money, and where's the money going? Because like he declared an emergency on March 9th and nothing was done to help the people in Wailua. So you know what, he's got too much power, so does the mayor. We need to rein him in, and you know what, a friend of mine on the Big Island is submitting an inquiry to his impeachment. So that's where I would challenge you to do that. Look, he needs to be reined in. This is not okay. We the people, you know, I back the Constitution. So thank you for your time.
Thank you very much for your time. Appreciate you being here. Ma'am, come on up and introduce yourself.
Hi, I'm Vernell Oku. I just wanted to say that I agree with the previous testifiers, and also I feel like because it doesn't have the protection for the constitutional rights of the people that are in an emergency situation, and also because it seems like when there is an emergency, it doesn't seem like the government is there. It's more the other people that are there helping other people. So I agree with them. This is giving the governor too much power, and he is not actually there anyway when we have an emergency and we need help. So it feels like it is overreach. And
Thank you very much. Is there anyone else wishing to testify on this measure? If not, questions, members?
Mr. Chair.
Rep. Garcia.
For Miss Alice, please.
Yeah.
Thank you for being here and you know, you mentioned, and I wanna first start off by saying that I agree that 127A is very broad and that the governor, in my opinion, has abused his authority in emergency situations. You mentioned that the bill is giving the governor sole sweeping power. Are you aware that HRS 127A is already the law? And the governor already has those powers, so the bill isn't giving him any new additional powers. He already has those powers, which is, and in fact, what this bill does is it actually gives authority to us, the legislature, to rein in those powers. Is that aware?
But, well, it's being abused. It was abused by Governor Ige and it's been abused by Governor Green. So something needs to be changed on the 127A. So, and I do understand that, but what I'm saying is that there are stipulations in there where he is giving, like he's able to seize property.
But that's
without due
already the law.
Huh?
That's already the law.
Well, it needs to be changed then, because that's disturbing.
Hold on, I agree with that, but this bill isn't establishing those powers. So my question is, why are we opposing it based on the assumption that this bill is giving the governor powers to go into properties without warrants or giving the governor's powers to violate the Second Amendment? I agree, those things are bad. But he already has those powers, and this bill is simply saying the legislature now has the authority to rein in those proclamations by voting them as not right. So it actually gives checks and balances. So, last question. Is it your opinion that this bill should die? Yes or no?
I didn't read about the part where it's giving the legislature power back.
Really?
No, but you know what, I understand what you're saying, but with the abuse of Governor Ige on his emergency proclamations, and then now with Governor Green, over 90 proclamations that are not even emergencies, something needs to give, something needs to be changed on 127.
And that's why
Like, and
this
I agree
bill's.
with what she said about changing the
Right, okay.
amendments,
Thank you, sure.
but yeah, thank you, dear.
Thank you very much.
Thank
I
you.
have a follow-up, Chair.
Sure.
From,
Thanks for trying.
For Ms. Margaret, our Hawaii Christian Coalition, thank you so much for being here. I want to start off by saying I respect the organization and truly appreciate the work that you folks do here at the Capitol. Like similar, I guess I'm going to just ask this one question. Because you're asking us to vote no on this bill, right?
Correct,
So you would like to see the bill die, correct?
correct.
Okay, so if the bill dies, then the governor's powers would remain as is, which is he has sole authority, he has broad power, he has no checks and balances, and the legislature has no ability to override his decisions. So would you rather prefer him to have unchecked power?
No, he definitely needs check power.
Okay.
However, I believe we met with the caucus, we met with other representatives and presented amendments and they were not received. So yeah, I would love to see imminent danger, imminent threats removed, a better description of disaster. And it was great that the one amendment on simple majority, that's a good amendment. But yeah, I'd like to see the bill die.
So what you're saying is you like what's there, but you would like to see it go further in repealing the governor's powers, which I agree with, in that it's way too much power. And I don't know, I mean, I guess just my basic reading of the bill, it's giving the power to the legislature to say, Governor, you have way too much power. I'm gonna now override your emergency proclamations. Now, I get the amendments to the disasters and that, but I'm just curious as to why it wouldn't be supporting it with amendments versus opposing, because if the bill dies, the governor has unchecked power.
Well, are you gonna amend it?
Well, I'm not the chair, but I would love to have it amended, for sure. I'm not the chair. Chair, would you amend the bill? But
Well, like I said in my testimony, if you amend the bill, we would support it. But as it's written, we took one step with the simple majority, but we got 2 miles to go.
right, I get that, but if the bill dies, we're taking a step back.
Well, you need to repeal all of 127A, in my opinion.
All right, thank you, Chair.
Thank you very much for those questions. Any other questions, members? If not, thank you. We're gonna move on to the next measure. Thank you to the testifiers for being here today. Next measure, Senate Bill 3083 relating to protective orders. This measure requires notification to the security forces of each branch of the military when a protective order is issued in a case involving a military affiliated individual. It requires the Judiciary, Department of Law Enforcement, and county police departments to establish certain policies and procedures. Lori Moore, Military and Community Relations Office, Department of Business, Economic Development, and Tourism.
Aloha Chair, Vice Chair, members of the committee. Zoe Wilkes testifying on behalf of Macro for Lori Moore. Hawaii is home to one of the largest military populations in the nation. Active duty service members, reservists, National Guard members, veterans, and their families are integral members of our communities. When domestic violence occurs in these households, victims often navigate both civilian and military systems that have not had an established arrangement for communicating with one another. This measure requires the judiciary, county police departments, and the Department of Law Enforcement to work in consultation with designated military security forces to establish interagency policies and procedures while safeguarding victim confidentiality and ensuring compliance with applicable federal and state laws. This measure would meaningfully improve communication, strengthen protections, and support victims across systems rather than leaving them to navigate those systems alone. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure? If not, questions, members? If not, we'll move on to the last measure on the agenda for which we're taking testimony. Senate Bill 709, Senate Draft 2, House Draft 1, relating to mental health. This measure requires the Department of Health to respond to reports of persons with severe mental illness who need assistance, assess whether they meet criteria for assisted community treatment, and coordinate the assisted community treatment order process when appropriate. It provides that denial of a petition for involuntary commitment serves as notice to the Department of Health to evaluate the individual for assisted community treatment. It requires the Department of Law Enforcement to adopt rules establishing training and certification standards and procedures for crisis intervention officers. It requires the Department of Health to approve the content of such training, clarifies the scope of treatment permitted under assisted community treatment orders, requires the Department of Attorney General to assist with the preparation, filing, and presentation of requests for a court or administrative order to provide treatment over a patient's objection. First up, we have Department of Law Enforcement. Not present. Next, we have Attorney General.
Good afternoon, Chair, committee members. Ian Suda with the Department of the Attorney General providing testimony and support. The department believes this bill will provide impactful clarification for laws relating to mental health intervention, which will have a meaningful effect on the ability of law enforcement and healthcare professionals to provide care to those in need. We are recommending amendments to the sections regarding the department's involvement in proceedings to obtain authorization to administer treatment over objection. Our proposed language will clarify that the authorization for AG assistance pertains to court proceedings for treatment over objection. This addresses the concerns of facilities wanting the AG to provide said assistance in conjunction with the assistance we're already providing in obtaining orders for involuntary hospitalization. Thank you, and I'm available for questions.
Thank you very much. Next, Hawaii State Department of Health.
Aloha, I'm Kenny Fink with the Department of Health, providing testimony in support of this measure. Sections 3, 5, 6, and 7 are generally from Senate Bill 3078, which was an administrative bill. The content of those sections are a priority for the administration, which we support. Just wanted to speak briefly about sections 2 and 4. Admittedly, the Department of Health has not done a great job in pursuing ACT petitions for patients within its care. And we've acknowledged that and we are working hard to address that. We have increased significantly the number of petitions for those upon being discharged from the Hawaii State Hospital. And we're looking to explore the process to do that for those that are seen repeatedly through the Behavioral Health Crisis Center. it's helpful to have multiple points of contact to be able to make the case for someone to need to have an ACT ordered involuntary treatment. Okay, our let's say lack of having done that previously in a consistent manner was not due to any legal deficit or lack of law, but to frankly a lack of execution, and we need to own that. These two sections don't give us any authority that we don't need. So for that reason, for sections 2 and 4, so for sections 2 and 4, section 2 regarding crisis outreach, we already do crisis mobile outreach and provide appropriate responses. This will require an ACT petition. Seeing someone at one point in time, if they are in crisis, there are other tools that are more appropriate for that single encounter, whether it's an MH2, MH1, or potentially an MH4. Those are the more appropriate paths for that single point of contact. And we're just trying to utilize our resources in the most appropriate manner. Requiring the ACT part is, I think, not appropriate in that particular setting. There are other tools that should those individuals be identified, referring them to other community partners for ongoing care or intensive mobile treatment will be more appropriate. As we get into section 4, there already is law, as I understand, under HRS 334-121.5 that already requires through involuntary hospitalization the assessment for an ACT petition. So we think that section is not necessary as well. So respectfully, we want to indicate our support for sections 3, 5, 6, and 7, and as our testimony indicates, withdraw that sections 2 and 4 are not necessary.
Thank you very much. Next, Lou Erdicek.
Thank you. Good afternoon, Chair Tarnas, members. I'm Lou Erdicek. I'm the Director of the Disability Rights Center. You have my written testimony, and if you look at my written testimony, I had a lot of strong objections to this bill, and in response to that, actually I had a really good meeting with Ian and Mike Champion to try to get a better handle on what they're trying to accomplish with this bill, and they did hear me out, and they did it. And I think if you look at their testimony submitted today, certainly the testimony from the Attorney General reflects exactly the point that I was raising, that the prior version involved them more in this administrative order to treat, which to me didn't make any sense. Whereas if the intent is to involve them only in court proceedings, I may have some hesitance about that, but I'm certainly less opposed to a situation like that. And also, when I met with them, I said a lot of this is in current law. You don't really need this authority, and so apparently they're suggesting that we delete some of those sections. So I think if you look at the testimony, it's probably improved over the version that's in front of you. I think I still do have a couple of concerns. One is, and I understand that the goal is to make assisted community treatment a little more holistic rather than just administering medication, and I think that's good. But I think the current law already has enough language in it to do that. I'm not sure that I'm a little troubled by the addition of the language in what constitutes assisted community treatment when they talk about blood tests and urinalysis and supervising where they live. This sounds more like the kind of stuff you do when there's a criminal that you put on probation and you make these conditions of probation. This is supposed to be a civil proceeding. These are not defendants. So I'm not sure that language is appropriate to add into the bill. The procedural concern that I wanted to raise, which I did raise in the prior committee, is that, and I'm no expert in the 3-reading rule or the gut and replace rule, but this bill, Senate Bill 709, was heard last session in the Senate. It was sent to Ways and Means. It was never heard this year. What happened was that there was an administration bill that never got heard by either chamber, and then the administration went to Senate Ways and Means. They found this vehicle, and they basically inserted the contents, sort of what you see now, into that bill, and then it crossed over to the House. So this particular version was not heard this year it all in the Senate. So again, I'm not an expert on that, but I would suggest, and just lastly, I think there's a generalized concern that not just me, but other people in the advocacy, because I'm reading testimony from some of my colleagues, and I think a lot of us, we could debate the merits of ACT, whether it's good or it's bad, but there's a lot of us, certainly myself, who believe that because these people are not granted an attorney in the proceedings, and that was a decision the legislature made a few years ago, so I'm not here to beat a dead horse, but because they don't have an attorney in the proceedings, we believe that the whole thing is fundamentally flawed. And so when you see a bill that on a surface seems kind of minor and not that big a deal, on the one hand, when we deal with the bill in front of us, that's true, it's not that big a deal. But on the other hand, if you have a system that's potentially unconstitutional to begin with, then anytime you add any little piece to that in and of itself, you're adding to an unconstitutional system. And I think that certainly is how I would look at it, and that may be what some of my colleagues are referring to as well, so, thank you.
Thank you very much, Lou, I appreciate your testimony. Next, Jim Gottstein on Zoom.
Thank you. Aloha, Chair, Vice Chair, and members of the committee. My name is Jim Gottstein, and I've lived on Maui for 6 years. I submitted written testimony in opposition to SB 709, and I want to emphasize some things in it. But first, let you know that I was lucky not to have been made permanently mentally ill by this system. Also, I have won 5 Alaska Supreme Court appeals ruling various aspects of Alaska's involuntary psychiatry proceedings unconstitutional or otherwise illegal. I recently joined the Hawaii Disability Rights Center PAMI Advisory Council as an attorney member. One of PAMI's PAMI stands for the Federal Protection and Advocacy for Individuals with Mental Illness Act, which I suspect you all know, and Lou is the head of that.
I appreciate you defining the acronym, because we try not to use acronyms in this committee if we can help it, but please proceed.
Mm-hmm. And one of PAMI's 2 purposes is to enforce the rights of individuals with mental illness. However, I'm speaking in my personal capacity. In order to constitutionally drug people against their will, the state has to prove it is in their best interest and there is no less intrusive alternative. The state doesn't get to evade this constitutional restriction by failing to fund feasible, less intrusive alternatives. The current ubiquitous use of neuroleptics, misleadingly marketed as antipsychotics, often forced into people against their will, reduces the recovery rate of people diagnosed with serious mental illness from a possible 80% to 5%, and reduces lifespans by around 20 years on average, while catastrophically diminishing the quality of life for most. I know this is hard to believe, but that is why I included the report on improving mental health outcomes as an attachment to my written testimony. It is meticulously referenced with links to the sources, and it has never been rebutted. It also lays out what sorts of approaches should be taken instead. For constitutional analysis, these other approaches are less intrusive alternatives that have to be provided instead of the forced drugging. As the report on improving mental health outcomes shows, forcing psychiatric drugs into people cannot properly be proven to be in their best interest, and there is almost always a less intrusive alternative. SB 709 goes further in the unconstitutional, very harmful, and counterproductive psychiatric drugging against people's will in the community. Lou spoke to this a little bit. So I urge the Judiciary Committee to reject this bill. I'd be pleased to respond to any questions.
Thank you very much, Mr. Gottstein. Final testifier, Raylene Reno-Yeomans on Zoom, not present. Anyone else wishing to testify on this measure? If not, questions, members? Rep. Shimizu?
Attorney General, please. I was wondering if you are familiar with the amendments that were offered by Director from Department of Health deleting sections 2 and 4, and also the amendment from Director from Department of Law Enforcement, just revising the training requirement, and if DG was okay with that.
I am familiar with the proposed amendments. I can say it, you know, it's not included in our testimony, a position on those things, but I can say that, you know, I understand the basis for those things, and I agree, as Director Fink had indicated, it is duplicative. Section 4 is duplicative of powers that are already there, mechanisms and entryways for treatment. As well, and they already have a crisis intervention system that is designed to be able to respond to individuals in crisis as well, and I believe the amendment from DLE is you know, kind of more of like an administrative one, making sure that you know, it's within their authority so that they can better execute the ability to certify and create trainings for these individuals. So I see no issue with those amendments.
Thank you.
Other questions? I do have a question for Mr. Udricek.
Yes.
So if I understand your testimony correctly, you have no objection to the amendments recommended in the testimony from the Attorney General?
I would say I'm certainly much less opposed than I was, because I mean, it does change current law a little, and I don't know if it's really clear. My understanding is that the Attorney General does not typically represent the community hospitals, and so at least this is what I learned in my meeting with these folks.
So
that
he wants to remove or administrative.
Yes, as long as if it moves administrative, it solves most of the concerns that I have, yes, right.
Okay.
I mean, that's basically.
How about the Department of Health, their recommendation to remove section 2 and section 4?
Oh, that's exactly what I was suggesting, it
So
should be done, yes.
You're okay with
I
that?
do support that, and you have the rest of my concerns for your consideration.
Yeah,
Okay.
we'll have to work on the legal representation issue, that's not in this bill, but I appreciate that is a remaining concern from even last year, so.
It is, and I do hope that at some point we could.
It's a valid concern, and
This has been a lingering issue for several years, as you can appreciate.
We'll have to work on that in a separate measure, but I just wanted to make it clear.
But in terms of what's in front of us, yes, right, yes.
Okay, good.
Chair Torres, I
Thank you.
have one question for Department of Health.
Sure.
Dr. Fink. First, I really appreciate that you're owning the Department of Health's you know, execution challenges, and that hopefully placing more folks coming out of the state hospital on ACT is happening. When I look at section 5 of the bill and I see you know, the outlining of residential services, alcohol and substance abuse treatment, you know, I think all of those things were already embedded in the language, but I think calling it out is a good thing. So are you saying now that individuals who may be cycling through the jails into state hospital are now getting ACTs that are identifying these things in their plans?
I can say that we are increasing the number of petitions for ACT orders. I would need to get back to you on the content of the treatment plans in those orders.
Okay, I think that would be really helpful, because I think that's actually exactly the piece that we need to make sure that when these individuals are leaving the system, the plans are outlining exactly the services they're supposed to be getting. Again, I think the law already said that, but if we have to call it out and then make sure they get those services so they're just not released out into the public without the services, which is what was happening in some cases, that we need to really make sure that these things are followed up on. Because all of these things are those wraparound services that we pay for in the AMHD contracts, as I understand it. Is that correct, Chair? I mean, Director?
To the extent those contracts include the application of the ACT order and providing that treatment plan, then that would be correct.
Okay. Thank you. Thank you,
Okay.
Chair.
Sure. Representative Takayama.
Just a quick question, Doctor, while you're still up there. Can you quantify the number of ACTs you've obtained, say, in the last year?
I'm going to look over to people who have more detail. From the state hospital, the last check was 15 petitions, maybe higher. It takes, I'm gonna, as part of our system, would you mind asking that question to my colleague?
Please come up and introduce yourself, and Chair Takayama could ask the question again.
Hi, Courtney Matsu, Deputy Director for Behavioral Health.
Dr. Matsu. Question was, could you quantify the number of ACTs you've obtained in, say, the last year, 2025 or so?
So I think a better indicator would be to consider from perhaps around October until now, because prior to that, the number of ACT petitions that had been filed from the state hospital in the preceding years have been less than 5.
I'm sorry.
Less than 5.
Okay.
Maybe 1 per year perhaps. Since then, we've relooked at our procedures and they've identified folks who are who they feel would benefit from an ACT petition and have filed. It's a lengthy process, so I believe 4 might have been filed. I would need to double check on that. But for that whole ACT order to be executed, it takes a long time.
And are they usually granted, or what are the, I don't know, percentage, or what's the likelihood that
Those
your
are all
petitions
pending.
are approved?
They've all been filed and
And
it's going
we
through
don't
the
have enough of a
process.
past record to tell us what
No.
your percentage success or grant petitions being granted.
Yeah, we just haven't had enough time for it to go through the process because it does go through AGs, the courts, they need the hearing, and it's been a lengthy process for that.
Okay, so you said about 5 in the last 6 months, is that correct? Since October?
I wanna say yes, I can get back to you to confirm
Okay,
the
alright, thank you. Thank you, Doctor. Thank you, Chair.
Yeah, if you could give us those details after you go back and look at it and get the information and send it to me and I can share it with the members. Because we're trying to get a handle on how you're currently operating and as we're considering making more changes.
Okay.
That'd be great, thank you.
Thank you.
Any other questions, members? If not, thank you very much to all the testifiers on all these measures. Let's go to the top of the agenda. We have quorum so we can do decision making. Senate Bill 2253, Senate Draft 2, House Draft 1. Members, I want to address the issue that was brought up in questioning with the prosecuting attorney about what I think is an unintentional confusion that's caused by the language in the bill. I think we can address this by on page 2, after line 7, add the sentence, quote, this is subparagraph 5, nothing in subsections 3 or 4 shall be construed to limit the availability of multiple convictions, cumulative sentences, or separate offenses otherwise permitted under law for conduct described in subsection 1A or B. That's my recommendation to this bill. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2253 SD2 HD1 with amendments. Chair and Vice Chair vote aye. Representative Bellotti.
Aye.
Representative Hashem. Representative Kahaloa.
Aye.
Representative Sayama. Excused Representative Takayama.
Aye.
Representative Cochran. Excused Representative Garcia.
Aye.
Representative Shimizu.
Aye.
Chair, your recommendation is adopted.
Thank you. Senate Bill 2429, Senate Draft 1, House Draft 1, relating to traffic safety. On this measure, members, I would like to adopt the amendments from the judiciary and from the Attorney General, make technical amendments for clarity, consistency, and style, and I want to define the term pedestrian priority area. Well, actually, I wanna define that term. So the definition I suggest is pedestrian priority area means a roadway or geographic area that is formally designated by a county by ordinance, resolution, administrative rule, or traffic control device as an area in which pedestrian safety is prioritized and for which special traffic controls, speed restrictions, or pedestrian-oriented design features are in effect, end quote. That way we're not using a term that's not defined. And this would be in chapter 291C. And then I want to make sure that we're clear about a couple of matters here about liability limitation to applying third-party conduct. So this is on page 6, lines 2 to 8, sections 286E. I want to add this language. Quote, subsection A, a manufacturer, distributor, or retailer of a motor vehicle shall not be liable for any loss, injury, or damages caused by the design, manufacture, or installation by a third party of an active intelligent speed assistance system, or improper installation, use, or misuse by a third party or vehicle operator of an active intelligent speed assistance system, end quote. And then technical amendments for clarity, consistency, and style. Oh wait, I have one more. And then subparagraph B, notwithstanding subsection A manufacturer, distributor, or retailer of a motor vehicle shall be liable if the manufacturer, distributor, or retailer knowingly or intentionally installs, repairs, or updates an active intelligent speed assistance system, and the installation, repair, or update approximately causes loss, injury, or damage. So I think that makes it clear about liability in this bill. So that change plus the technical amendments for clarity, consistency, and style. I am leaving blank the number of violations and the miles per hour over the speed limit for designated habitual speeders. And as you heard in my questioning, I've requested input from the AG and judiciary on that for conference committee. Those are my suggestions, questions, or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2429 SD1 HD1 with amendments, Representatives Sayama and Cochran are excused. All other members are present. Are there any voting no?
No vote.
No for Representative Garcia. Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2697, Senate Draft 1, House Draft 1, relating to transportation. On this matter, I'd like to adopt the amendments from the Attorney General in their testimony. Technical amendments for clarity, consistency, and style. I would like to clarify the look-back periods for making sure this is clear because it's not clear right now. So I would suggest on page 1, this one, the first one. Oh. Thank you. My very smart attorney said that that is addressed by the Attorney General in their testimony, so I won't have to do that. The second one, on page 3, lines 4, I want to specify that the rules would be adopted pursuant to Chapter 91, because you know I like Chapter 91, because it includes public input, and that's important. And then I'd like to make technical amendments for clarity, consistency, and style. And then I want to delay the impoundment provisions by 1 year after the effective date of the bill, so we can give a chance for the city of, and County of Honolulu and the counties throughout the state to work with the Department of Transportation to be ready for implementation. That tries to address the concern that you were going to bring up with the city and county.
Try to say that again, I'm so sorry.
So I want to delay the impoundment provisions by 1 year after the effective date of the bill to give a chance for the counties to work with the Department of Transportation so they can be able to implement this properly. Because I think that was part of their concern.
Okay.
Those are my recommended amendments. Questions or concerns, members?
Chair?
Yes.
I appreciate your thoughtfulness. I feel like there's a lot of issues that city and county brought up that I wasn't able to clarify, and I just have a lot of misgivings with how all of this is gonna work. So I'm sorry, but I'm gonna be voting no on this.
Sure, no, don't apologize, it's okay, you gotta vote the way you gotta vote. Any other comments or concerns? If not, Vice Chair for the vote.
Voting on SB 2697 SD1 HD1 with amendments. Representatives Sayama and Cochran are excused. Are there a no vote for Representative Shimizu? Any additional no votes?
No vote.
No for Rep. Garcia. Any with reservations? Recommendation is adopted.
Thank you. Senate Bill 2852, Senate Draft 1, House Draft 1 relating to civil rights. I'd like to adopt the amendments from the Attorney General, which I think would cover the same recommendations coming from the Hawaii Civil Rights Commission. So we're just gonna adopt amendments from the Attorney General. Technical amendments for clarity, consistency, and style. And Mr. Gashel, I did listen to your recommendations. I would suggest that we need to include those in the rules rather than in statute. If the committee agrees and it moves forward, it would go to conference committee. And so if we need to make additional changes, we can certainly make them in conference committee. But for now, technical amendments, AG amendments, and move this forward to conference. Questions or concerns, members?
Chair, I'm just gonna be voting with reservations.
Okay. Any other comments? If not, Vice Chair for the vote.
Voting on SB 2852 SD1 HD1 with amendments. Representatives Sayama and Cochran are excused. Are there any voting no? With reservations for Representative Shimizu. Any additional reservations?
Reservations.
Reservations for Representative Garcia. Recommendation is adopted.
Thank you. Senate Bill 2471, Senate Draft 2, House Draft 1 relating to the powers of artificial persons. This is a very important measure. It obviously has gotten a lot of feedback and testimony both for and against. I think this merits further discussion, and I would like to move this forward to conference committee, even with the concerns that have been voiced by the Attorney General and others. I'd like to make technical amendments for clarity, consistency, and style. I do want to make a couple of other changes. On page 5, lines 13 to 14, I would like to define the terms candidate, political committee, and political party, because they are not defined. On page 24, lines 12 to 18, to address questions regarding the charter privileges, which are mentioned in the bill but not defined. I want to amend the language to say, quote, "A limited liability partnership that engages in either activity shall forfeit its statement of qualification, including limited liability as a matter of law." I think that would address what LLPs, limited liability partnerships, are. That's the laws that are specific to limited liability partnerships that I think we need to include in there. And then on page 32, line 1 to page 35, line 5, it's unclear why section 428-111 is not amended to also add language similar to page 28, line 13 and page 30, line 3. So I would like to correct that. And then finally, technical amendments for clarity, consistency, and style. I want to note in the Standing Committee report that the Department of Commerce and Consumer Affairs has indicated that an appropriation may be required for their business registration division to hire and train new staff and make system adjustments. And I would also note in the Standing Committee report that this committee acknowledges that the Attorney General has testified that about their serious concerns about constitutionality of this measure. That being said, I still would like to move it forward. Questions or concerns, members?
Chair.
Yes, Rep. Garcia.
Thank you. I understand this is a controversial subject nationally and locally. However, the concerns brought forth by the Attorney General I think is serious and it's warranted. I believe that if this bill passes and we end up facing lawsuits, this will subject Hawaii taxpayer dollars to the expense of who knows how many millions of dollars. So out of an abundance of caution, and knowing that the Supreme Court and the federal courts is pretty much set in their way as of right now, I'll be voting no. Thank you.
Understood. Other comments?
Chair.
Rep. Shimizu.
You mentioned DCCA in the committee report needing more money. What about their request to defer to campaign spending commission?
After listening to Mr. Moore and Chair Bellotti, it was made clear, I felt, that this was not the purview of campaign finance, but rather the purview of the corporate law sections of our Hawaii revised statutes. And so that's why I did not include campaign finance in this.
Okay, I mean, I'm totally against Citizens United and the influence of corporate money. It's very difficult to vote against Attorney General saying we're gonna pass something that's gonna be illegal. But I'd like to move it forward and have the opportunity to maybe vote no in third reading. But I'm gonna vote yes with reservations.
Okay. Other comments? Chair Bellotti?
Chair, I just wanna thank you for moving this forward. I know that there are legal concerns, obviously, and they've been well documented. But I do think that, you know, a theme that for me is emerging in this legislative session is about the powers of the legislative branch. And this is solely within the powers of the legislative branch. I also think another theme that's been emerging is what are the powers and authorities of the states. And so Citizens United has been a scourge on the nation. Our federal system is built on a system where states have autonomy and authority. And so I think this is a completely proper exercise of our authority. And if it has to be litigated because there's an open question, then we should not be afraid of that, because we are actually asserting our state authority on behalf of the people of the state of Hawaii, and that is our obligation. And so I really appreciate that this is going to be able to continue so that we can have this very important conversation. Hawaii has led in many other ways, and this is certainly a way that we can lead the nation now. So thank you, Chair, for letting this idea go forward, and I'm looking forward to more conversations we're going to have.
Thank you. Other comments? If not, Vice Chair for the vote.
Voting on SB 2471, SD2 HD1 with amendments, Representatives Sayama and Cochran are excused. Any voting no?
No vote.
No for Rep. Garcia. With reservations for Representative Shimizu. Any additional reservations? Recommendation is adopted.
Thank you. Senate Bill 2568, Senate Draft 1, House Draft 1, relating to offenses against public servants. I would like to take the recommendation from the judiciary and their testimony to insert the definition of public servant that was in House Bill 2092, House Draft 1, which basically says public servant has the same meaning as in section 710-1000. It is a broader definition of public servant. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2568, SD1 HD1 with amendments, Representatives Sayama and Cochran are excused. Are there any voting no? Any with reservations?
Reservations.
Reservations for Rep. Garcia. Recommendation is adopted.
Thank you. Next bill, Senate Bill 2151, Senate Draft 2, House Draft 1, relating to emergency management. On this measure, I would like to suggest making a couple of amendments just to make sure that we're clear about the limitations that we're placing on the governor and mayor regarding their emergency declaration powers. Page 2, lines 15 to 20, subsection would read, subparagraph A, the governor or mayor shall not, through any proclamation or declaration of emergency or any rule or order adopted pursuant to this chapter, suspend or deny access under the authority of this chapter to 1, records pursuant to chapter 92F, or 2, vital records or statistics pursuant to sections 338-18. Then on page 3, lines 1 to 4, I want to clarify subsection B to reinforce this section does not limit an agency's authority to deny access to records on grounds otherwise authorized by law. So the subsection could read, quote, subsection B, nothing in this section shall be construed to limit an agency's authority to deny access to records or information on grounds otherwise authorized by law. Due to the extenuating circumstances, there may be a reasonable delay in an agency's response to a request, provided that an agency shall not reject or refuse to accept a request solely on the basis of an emergency declared under this chapter, end quote. And finally, on page 6, line 17 to page 7, lines 5, and again on page 11, lines 20 to page 12, lines 10, I want to add to section 127A-13, subsection A3, should also be applied to the limitations added to section 127A-13A3 should also be applied to section 127A-13A2, which independently authorizes the suspension of laws. So, because without a parallel except as provided clause, subsection A2 may be read to permit suspension of laws, notwithstanding the new section restricting suspension of access to records. So I want to make sure that this language in this bill applies to both of those provisions. With those changes, I would like to move this forward. Questions or concerns, members?
Comment, Chair.
Yes.
Thank you for that, and I thank you for the amendment. I think it's even strengthening the intention of the bill. It's my opinion that the governor, and not just our current governor, but previous governors have abused their powers of emergency, and I am actually happy to see a bill that's moving forward, not perfect, but a step forward in the right direction, that is actually establishing a check from the legislative branch of government to I guess override a governor's proclamation if we deem it unfit. And so I just want to establish that this bill is not giving the governor any new powers. He already has those powers in 127A. It's simply establishing our ability to override his proclamations if we see them as unfit or unconstitutional. So for those reasons, I will be voting yes. Thank you.
Okay. Other comments?
Chair,
Rep. Shimizu.
Thank you. I would echo my colleague Rep. Garcia. I share the concerns of the opposition that was presented today and in previous committees, and I acknowledge exactly what was said. The existing law gives the governor far-reaching powers that's really questionable. But the positives of this bill to give power back to a simple majority of the legislature and defining, giving definitions to an emergency, and the amendments that Chair Bellotti considered and accepted the simple majority in public safety. In the short time that I've been in this seat, I used to think that I could get all, but it's better to get something than nothing, and I support this bill, even if it's not as much as we would like it to be ideally. So I will be voting yes also.
Okay, thank you. Other comments? If not, Vice Chair for the vote.
Voting on SB 2151 SD2 HD1 with amendments, Representatives Sayama and Cochran are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Okay. Next, Senate Bill 3083, Senate Draft 2, House Draft 1, related to protective orders. On this one, I would like to move it forward with technical amendments for clarity, consistency, and style. You're okay with these? Thank you. But I'd also like to make some additional, I would say, clarifying amendments. On page 3, lines 9 to 11, the definition of military in subsection D is unnecessary because the section's operative provisions rely on the separately defined term security forces of each branch of the military, which already specifies the covered entities. So I don't So we can remove that definition of military in subsection D. On page 3, lines 12 to 17, the listed entities there are the military criminal investigative organizations responsible for serious offenses involving service members, except the Marine Corps is covered by NCIS, so listing the Marine Corps Criminal Investigative Division is not necessary, so we can remove that. And that the United States Army Garrison Hawaii is not a criminal investigative or security force, so I think we would remove that too. So that change with technical amendments for clarity, consistency, and style are the changes I would like to make to this. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3083 SD2 HD1 with amendments. Representatives Sayama and Cochran are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Okay, next bill, Senate Bill 709, Senate Draft 2, House Draft 1. On this measure, I will accept I recommend that we adopt the amendments recommended by the Department of Health and by the Attorney General. But I'd like to make some additional changes. On page 5, line 8, I would like to delete the words without regard and replace it with pursuant, so that the sentence would read, the director pursuant to Chapter 91 shall adopt rules setting forth statewide training and certification standards and procedures for a crisis intervention officer, and the Department of Health shall approve the content of training for crisis intervention officers established pursuant to this section. I want to be consistent because I like Chapter 91. And involvement of the community and stakeholders, I think, is a good thing. Starting on page 5, line 13, section 4 is amended to incorporate changes that were made to section 334-60.5I by Act 219 from 2025. So I want to make sure that this language in this bill is consistent with the bill that we passed into law last year. I would like to restore language that this bill proposes to delete on subsection B, page 8, so that it would be restored to read, quote, for the purposes of this section, imminently dangerous to self or others means that without intervention, the person will likely become dangerous to self or dangerous to others within the next 45 days. I want to keep that definition in there, as opposed to what this bill proposes to do is take it out. I would like to defect the effective date to July 1st, 3000. And then in the standing committee report, I would like to note that my concern that the Senate subject matter committees did not hold any hearings on the language in the Senate Draft 2 that the House received. And I will leave it at that. Because all of you heard the testimony from Mr. Erdachek that language was inserted into the Bill and Ways and Means Committee, and that the earlier subject matter committees never had a hearing on the language that was inserted in Ways and Means. So I just want to note that in the standing committee report as something that everyone should be aware of. Those are my recommended changes, right? Everything? Is there anything HMSO?
Oh, we got DOH, right?
Yeah. And HMSO.
Yep, and you got HMSO. Yep.
Yep, okay, so I got everything in there. Those are my recommended changes. Questions or concerns, members? It's a complicated bill, sorry. Yep.
Chair.
Yes.
What about Department of Law Enforcement's amendment, just tweaking the language regarding their setting up procedure with Department of Health?
Yes, thank you for that question, and I want to clarify, I want to make it clear why I am not recommending we adopt it. It's because this is not just tweaking the language. This is a significant change. 2 significant changes would be in here. What this language here that they're asking for would exempt them from chapter 91 rulemaking process. So they would not have to go out to public hearing.
I see.
It would also only require consultation with the Department of Health as opposed to approval by the Department of Health. And I think in this matter, we need the approval, review and approval by the Department of Health. They need to put their stamp of approval on it and not just have Department of Law Enforcement consult with them.
Thank you for that clarification. I agree.
That's why I'm not accepting their recommended amendment.
Thank you, Chair.
Yeah, any other comments or concerns? If not, Vice Chair for the vote.
Voting on SB 709 SD2 HD1 with amendments, Representatives Sayama and Cochran are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Thank you. Final measure, which is a measure that we had heard previously. I had requested input from the administration, from the executive branch, Department of Law Enforcement, Department of Health, the Attorney General, and they worked hard and got back to me, and I appreciate that. And so with their input, as well as input from others, this is my recommendation. I'd like to move out Senate Bill 3142, Senate Draft 2, relating to dangerous intoxication with the following changes. On page 1, lines 11 to 13, subsection B, I want to replace the words that are there now, creates an immediate and substantial risk of physical harm to the person or to others, with the following words. And the person is acting in a way that poses an imminent danger to themselves or others. It's a higher threshold. And then on page 1, lines 14 to page 2, lines 2, I want to delete the subsection C, which states, quote, obstructs or interferes with the free use of a street, sidewalk, or other public way while exhibiting signs of substantial incapacitation after being provided a reasonable opportunity to comply with a lawful request to move, end quote. I just think that that subsection is just a step too far. And so I'm recommending that we delete that. On page 2, line 20 to page 3, line 3, I want to delete the sentence, quote, if the person requires emergency medical stabilization, the person shall be transported or caused to be transported to an appropriate medical facility for stabilization before any emergency examination is conducted pursuant to section 334-45. And I want to add the sentence in its place, quote, any individual placed into civil protective custody shall be transported in accordance with section 334-42C. So I think that's a more appropriate section to refer to. On page 5, lines 7 to 12, I would like to delete the definition of substance as it does not appear to be necessary in this measure. I'd like to add a delayed implementation date of 1 year to give the various agencies and entities involved in the provisions articulated in this bill enough time to prepare for this new approach. And I would like to defect the effective date to July 1st, 3000. Those are my recommended changes. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3142 SD2 with amendments, Representatives Sayama and Cochran are excused. Are there any voting no? Any with reservations? Recommendation is adopted.
Thank you. And before I adjourn, I just want to mention that these measures will go forward to conference committee. We would, members of the House and Senate, especially the co-chairs of the committees that have heard the bill, would look forward to receiving memos from interested members of the public or agencies to comment on the versions that are moving to conference committee. So if you have issues with those amendments that I just made, tell us about it, send us memos so that we can consider that in conference committee. So I just want to put that out there so the public understands and the agencies understand what the next steps are. Okay, there being no further business before this body today, we are adjourned. Thank you.